right. Mr. Franklin, it looks like Ms. Hawkins got a judgment against you that evicted you or was about to evict you from the premises. Are you out of the premises now?
No,
Have you been served with a copy of the judgment?
not physically. I've been on, I'm an over the road truck driver and I've been out since New Year's Eve. And I never received any notice or notification beforehand. She surprised me with this while I've been out on the road. And I'm still out of state right now.
Miss Hawkins is here.
All right.
And
Judith,
can I
go ahead, sir.
Just to let you know, it's not exactly a landlord-tenant issue. It's a fiancé issue. And as far as bills or payments, I owe nothing. I pay all the bills, all of them.
She's not asking, Mr. Hang on. She's not asking for anything other than to get you out.
Right. It's a matter of being able to work that part out, trying to get there and then get my property and all that resolved. I've tried to make a relationship work, and I've offered everything that I possibly can do to make it work.
I'm not here as a lawyer or a judge on anything other than a landlord-tenant matter, because that's the only thing that's in front of me. Is Judith Hawkins present?
Yes.
Ms. Hawkins, have you served a copy of the judgment on Mr. Franklin?
I took photos of it and sent it to his phone. I made him aware that I had refiled.
All right, the judgment was issued on January the 13th. You had 10 days. When did you send him a copy of the judgment?
Oh, no, sir, this is the new one. No, Danny hasn't been gone. He's been here. After our first court appearance, he cried and begged to me not to kick him out and let him please get a job, and he would save money and get a place. So he did get a job and he did save money, and then the job downsized him right out of there. So he's had many health problems. He had
Ms. Hawkins, I'm sorry. Yeah. I have 18 other cases to deal with today. So can you give me the Reader's Digest version of that, please? You mentioned two cases and or a new case.
Well, that's today.
What's that?
I mean, I just had to redo this through the courts because I asked how long that eviction was good for. And they said 59 days. So he's still here. And so I had to redo it and come before you again. That's what they told me.
I signed a judgment in this particular file on January the 13th of 2025. All right, I'm looking
That's
at
correct.
it. So that one's, and so you never did anything at all with that one. So are you telling me that you just recently redid something?
Well, yes, I just refiled the papers because I called the court and I said, how long was the eviction thing? Do I have to refile? And the lady had to check and called me back and said, yes, it's only good for 59 days. So that's why I'm redoing this and coming back before you because he's still here. I even found him a storage unit, told him I would pack up his things and put it in the storage unit. And yeah.
All right. So you want to apply for an eviction now based on your previous judgment? Is that what you're telling me?
Well, that's what I was told I had to do.
All right. Is that still your intent?
Yes.
All right, then I need you to, I'll grant that request, but I need you to file the paperwork for that so that I can sign that so that the sheriff's department can then make him move. Is there some Mr. Franklin, is there some reason that you're not going to be able to move within 10 days of a judgment being signed for eviction?
Yes.
Why is that?
Well, one, the company won't allow me to bring the truck home up there. And I have to find ways of getting up there. And then I got, you know, heavy stuff, stuff that takes more than one man to move. So I need to make the proper arrangements, and I work at least 80 hours a week. And yeah, it makes it kind of difficult.
Well, the statute says that once she files the appropriate paperwork, you have 10 days to get out or the sheriff moves your stuff. And typically they don't just put it where you want it. They just move it off the property. And then you
Right.
pay wherever they put it, you'd end up with the bill.
Do I have any type of legal standing on delaying this? I don't mind the moving part. I'm just looking for time.
I can't act as your attorney. All I can tell you is that you've got, under the law, you've got 10, once she signs the paperwork and sends it to me and I sign it saying that you got 10 days to move from that date. I don't know when that will be because I don't know when she's going to send me the paperwork. But once she sends it to me, there's already a judgment in place that she's entitled to have the property back. Once she sends me the documentation that says she can ask for the sheriff after 10 days, I sign it, then you've got 10 days to move.
Yeah.
Sir, was that sent to me from the court? I have notice to appear, proof of mailing. Was I supposed to send one of these back? I didn't see that. Or do I have to come to the courthouse and sign the papers?
There's an order for eviction form that needs to be filed. You can speak with Ms. Good about how to get a hold of that or where it's at on the court's website. Once we're done with today, then you send that in, you fill it out, you send it in. If it's in proper order, I sign it. And he's got 10 days from that date to get out.
Okay, when I called the court to ask about the having to redo this eviction, she said, oh, you don't have to do anything. He doesn't have to be served. I'm just going to send you the papers since you already have a case file. So I wasn't aware that I had to re-sign documents, or I would have did it already.
Okay, now you know.
Okay.
So call Ms. Good. Call Ms. Good tomorrow. Get the paperwork, get it signed, or get it filled out, then send it to me and I'll get it signed.
Okay, great. Thank you so much.
All right. Thank you. That's all for today.
Thank you.
Boathouse Marine and Power Sports versus Aaron Shattuck.
Good afternoon, Judge Paul Slough on behalf of Boathouse Marine.
Good afternoon, Your Honor. Alex Tolson on behalf of defendant Aaron Shattuck.
I have two motions, one by Ms. Shattuck regarding discovery responses and to compel discovery. And then I have a motion for summary disposition filed by plaintiffs. Let's take up the discovery issue first. Ms. Holzman, you want to argue that?
Yes, Your Honor. It's my understanding that the summary disposition motions are scheduled for February 23rd. And then today's date is for the motion to compel.
That's my understanding as well, Judge.
All right, I apologize. I guess we're just here on this one then, so go ahead.
Okay, thank you, Your Honor. This is Aaron Shattuck's motion to compel discovery. Ms. Shattuck sent out discovery requests to Boathouse back in November. Boathouse did respond to those requests. However, the responses are evasive and non-responsive and failed to provide information and documents requested. Shattuck requested, among other things, maintenance logs, invoices, and previously reported damages to the watercraft at issue. This information and documents requested in Shattuck's discovery requests are discoverable, relevant, and proportionate to the needs of the case. Shattuck discovery goes to critical factual issues of Shattuck's counterclaims, which allege breach of contract, fraudulent misrepresentation, fraud in the inducement, and violations of the Michigan Consumer Protection Act. The critical issue of Ms. Shattuck's counterclaims is whether or not the jet ski was defective and or damaged prior to Shattuck's rental period, and whether Boathouse knew that it was damaged or defective prior to that rental period. Maintenance logs, invoices, and previous damage reports all go to those issues, specifically whether or not Boathouse knew that the water jet ski in issue was damaged or defective prior to that rental period beginning. We did receive an invoice after we sent out a concurrence request for this motion from Boathouse. The invoice that we received provides no itemization of the damages, it just lists an amount. So we're unable to ascertain if that's for parts, labor, what those damages are repairing. Additional maintenance logs for the jet ski at issue go to whether or not this was damaged, if there's previous customer reports of damage, similar damage, when it was repaired, how it was repaired, and how often it was damaged.
Mr. Slough.
Yeah, thank you, Judge. The key question in the counterclaim is, was the jet ski defective when it was delivered? And we made a good faith effort to produce all the relevant and obtainable information. Specifically, we provided answers to interrogatories indicating the jet ski was inspected before it was delivered to Ms. Shattuck. It was operated across Otsego Lake when it was delivered to her, and there was no indication of any issue, mechanical or otherwise, with the jet ski. And in direct response to the motion, when we did produce the maintenance log, which indicates all the prior rentals and rentals that occurred after the rental in question with this particular jet ski, and the maintenance history. So everything relevant to the counterclaims in our possession has been produced. What defendant's motion was speaking to, as I understood it, was asking for other customer names and addresses, maintenance histories on jet skis that are not involved in this case. And, you know, those maintenance histories are irrelevant, it's overburdensome, and it's outside the scope of discovery. So we certainly have maintenance histories for other jet skis, but they're not relevant to this case.
Ms. Holtzman.
Your Honor, the maintenance history of both the jet ski at issue and other jet skis can be relevant to this case. Again, we're looking at whether or not Boathouse knew or should have known that it was renting jet skis that were damaged. That goes directly to the fraud and the inducement claim. It goes to the fraudulent misrepresentation claim, and it certainly goes to the violations of the Michigan Consumer Protection Act. Is this a standard business practice for Boathouse to engage in to provide rentals that are not in good working condition?
How do you get past the fact that the jet ski was driven across the lake to your client? How do we have fraud? How do we have damage? How do we have defective if that fact is true? And it appears to me from my review of your documents submitted that you've admitted that fact.
It goes to whether or not it was substantially damaged if there was pre-existing damage to the jet ski prior.
The pictures showed me that there were 2 rocks found in the impeller area of the housing. How is the jet ski supposed to function if it's got 2 rocks in it? 2 golf ball sized rocks.
Defendant's argument is that it was damaged in some way prior to the rental period. So what damage, if any, was existing prior to the rental period? When did the rocks enter the jet ski?
Well, that's what I'm talking about. Is it your assertion that the jet ski was operable to the extent that it came all the way across Otsego Lake from the plaintiff's business to your client's cottage or place where it was dropped off and the contract was signed in the condition that you gave it back to the plaintiffs?
The defendant's position is that it was operable for some amount of time during the rental period, but very shortly after the rental period began, it stopped working. So whether or not it had some underlying damage when it was delivered is relevant to the defendant's counterclaims.
All right. Mr. Slough, the pictures that were submitted, are those all of the pictures that were taken at the time that the housing was dismantled and the jet ski was repaired?
There were 2 photographs I included in my brief. I believe there were maybe a couple other photographs as well that were taken of the housing. They don't show anything else of, you know, any real substance. Actually, I take it back. There's several photographs that were taken. I picked the 2 that I felt were the most substantive, but all those photographs have been provided to Ms. Tolsman. I provided that as well as the invoice back in October of 2025 when the court asked us to produce everything that was relevant. We sent that to her by email. So they have all those photographs.
Ms. Tolsman, do you have anybody, or do you want to have the time to get somebody that could give me some indication that by reviewing those documents and or talking to the plaintiff that would say that it's possible to operate that jet ski in the condition as noted in those pictures?
Yes, if given the opportunity for time, I can see if I can find someone to look into that issue. Yes, Your Honor.
Because I would find it appropriate for you to get the discovery that you're looking for if that jet ski could be driven across the lake in the condition that it had the 2 rocks in it. Not trying to use my own personal knowledge of things like that in it, but it kind of stretches credulity. But I'm willing to give you the opportunity to show me some facts about that. I'm not going to speculate on it just because I happen to have ridden a jet ski in the past. So I'm going to give you the opportunity to do that, but I don't see the relevance if the jet ski could not have been driven across the water that far. So you can go into the background if you can show me that the jet ski could have been operated and would not have been noticeable to have 2 golf ball sized rocks in the impeller housing. So how long do you anticipate you would need for that?
A couple weeks at least, Your Honor. I think that's going to create an issue for our MSD because that is due next Monday to comply with the court rules to get that filed and served before the hearing on the 23rd.
So March 23rd is when or is it February 23rd?
It's February 23rd, Your Honor.
Well, why don't I have you see February 23rd, Mr. Slough, how much time are you going to need in advance to be able to respond if she comes up with somebody that says, yeah, it could have been done? I assume you're going to just use your client?
Well, I'm going to use my client, Judge, but I want to remind the court this case has been open now for some time. We've had discovery. She's had every opportunity as the plaintiff to produce whatever evidence in support of her claims she wants to produce. And we've properly noticed a summary disposition motion. And again, if they have facts they want to present to create an issue to bring it to trial, that's fine. But
I'm not pushing off your summary disposition motion. I want to know how much time in advance of that you want to get the information that she's going to send in.
Well, if she files a response within 7 days prior to the hearing, that's just fine.
All right. So, Ms. Tolsman, any new discovery information or new expert that you want to use, that information needs to get to Mr. Slough prior to 7 days in advance of the February 23rd hearing on the motion for summary disposition.
Understood, Your
Any
Honor.
question? All right.
No, Your
So
Honor.
I'll see everybody on the 23rd. We'll take up if there's any new information on discovery, we'll take it up at that time, and then I'll make a decision, and then we'll proceed directly into the motion for summary disposition at that time. Thank you both very much.
Thank you, Your Honor.
Okay. Thank you very much.
Your Honor, I don't mean to interrupt. This is Susan Garver. I'm here on the Otsego versus Gerard case. I just got a call that my sister's house is on fire. I swear
Please go attend to that.
I'm not making this up. Can we call mine quick so I can attend to that?
James Munson versus James Gerard.
Yes.
Your Honor, I'm also here on Munson versus James Gerard from Plaintiff.
Yep, let me get it called and I'll do it as quickly as I can. All right, this is Munson Healthcare versus James Gerard, 25-41243 GC. Counsel, you want to put your appearances in for Munson and then defense?
Thank you, Your Honor. Nicholas Evers, P88829 on behalf of the plaintiff.
Susan Garver, also on behalf of the plaintiff in the defendant plaintiff counterclaim for Munson.
All right. I have received an answer in this case which alleges, it doesn't tell me a dollar amount, but it alleges that the damages are in excess of the district court jurisdictional limit. Does that continue to be true, defense counsel?
I represent Munson in the counterclaim where plaintiff is alleging medical malpractice, and he says that it's in excess of the jurisdictional limits.
All right, I
don't
apologize.
have any.
I misunderstood how you were involved in the case.
Yes.
Do we have Mr. Gerard present with us?
I am present. Yes, Your Honor.
Mr. Gerard, your counterclaim makes an allegation that you're there's the jurisdictional.
Sorry.
What are you asking for?
Actually, I think I put on there that it may be and that it was going to be up to the discretion of the court.
It's not up to the discretion of the court what the claim is. That's your claim. I can't do that for you. I'm not your attorney. You
Correct.
tell me what you're asking for. What's your claim on counterclaim?
Well, first, I'm going to get an attorney because the counterclaim is for my lost wages and for the hospital bills that occurred after I went to Munson.
So how much is that?
I don't have that amount. So if I need to get my lawyer, I can get my attorney and then we can proceed with this forward. But I think the original, claim is that I'm unjustly enriched by this when they sent me away with a lung infection. And then I had to go to
Mr. Gerard,
a completely different hospital.
We're not doing a trial today. I need to know what your counterclaim amount is. Is it less than $25,000?
Yes.
Or more than 25,000? So you're saying it's less than 25,000?
It's less than, correct.
All right. So we're still here in district court. Both plaintiffs' attorneys or counterclaim attorneys for Munson, how much time do you want for discovery?
Your Honor, we'd like to get a date for C8 MSD if possible. And, if the court grants that, then we can, or denies it, then we can engage in discovery thereafter.
How fast can you file it?
2 weeks.
All right, so he's entitled to 7 days or so to look at it. So sometime 21 days from now, do we have a time where we get half an hour?
On Monday?
On a Monday, yes.
March 2nd.
Court staff is telling me that March 2nd at 1:45 would be the earliest that we could do that.
That's fine with me, Your Honor. Thank you.
No objections, Your Honor.
I'm sorry, who's asking?
Attorney Evers. Also for just no objections to that. That works for us. Yeah.
All right, Mr. Gerard, do you have any conflict with March 2nd?
I don't have a conflict with the date, but I would like to, if somebody could elaborate on what the request is from the plaintiff.
I'm filing
That's
a
what
motion to dismiss your case. I'll be filing a motion to dismiss your case.
Okay. And I'll have an opportunity to respond to that, correct?
Yep, she'll send it to you before at least 7 days before March 2nd, and then you'll have a chance to respond to it, and we'll have a hearing on it March 2nd. You're probably going to want to have an attorney at least go over that with you before you
Yeah.
respond or before you come to court.
And that's fine. I'll call my attorney.
Good. I know that counsel is wanting to get away. Is there anything else we need to do today?
Not for me, Your Honor.
Nothing for me, Your Honor. Thank you for allowing me to go next.
All right. Thank you. That's all for today then. Thank you, Mr. Gerard.
Thank you.
Thank you.
All right. This is Pagels Law versus Thomas Ignatiuk, file 25-40268-SC-3. Mr. Pagels.
Yes, Your Honor.
I just want to know if you want to put your appearance on the record.
Yes, Jim Pagels for the plaintiff, Pagels Law PC.
Thank you. Is Thomas Ignatiuk with us?
Yes, sir.
All right. Thank you for being here, sir. Looks like we were here last. Well, this looks like there's a civil discovery subpoena out scheduled for today. Mr. Pagels, do you have some questions that you'd like to ask Mr. Ignatiuk in a breakout room?
Your Honor, what happened very briefly last time is I did go into a breakout room and talk to him, and he produced none of the subpoenaed documents. We agreed, we came back in, he agreed he was going to pay off the full amount. He did not, and he has not produced the requested documents in the subpoena.
Mr. Ignatiuk, what's going on?
It's honestly just a matter of not having the funding, Your Honor. I did, after our last appearance, go to him with another $1,000 and tried to discuss things a little further. Since that time, it's just it's been a slow winter, and I don't have the funding. I obviously would love to make this problem go away and just take care of it. And then, thinking about it more and more, I feel like I've already paid well above and beyond our original agreement in this matter. And I just, it's just, a stressful situation.
Well, the time for determining what the amount of damages has come and gone. That's over with. There's already a judgment in place.
I understand that. That's not a reason I'm not paying. As I said, if I had the available funds, I would just take care of it at the moment.
Well, in addition, it's not just not paying. It's also not giving him the documents that he's entitled to have about your finances, your banking records, your tax records, all those kinds of things that if he's asked for them, he's entitled to have them. And he's giving you a list of those things.
I did partially fulfill that list, but upon our meeting, when I made my last payment to him, he said if I'm going to pay him, then I don't have to worry about it, which it is fully my intention to pay him. I just, over the last couple months since then, it's things have got rough.
Okay, when somebody says this or that, and you don't do this, then you have to do that. And if he said you can pay me, or you can give me the documents, you started to pay him, and he said, all right, while you're paying, you don't have to give me the documents, but now you haven't paid him, so you do have to give him the documents. Does that make sense?
Complete sense,
so
yes.
So how fast can you get him the rest of the documents?
I can get him most of the documents today. The only thing that is going to require more time is tax returns. I don't have that information readily available.
You don't keep your tax returns?
I'm behind on that. I'm currently working on getting caught up, but they are not filed yet. I have I'm working on.
He's entitled to what you have filed, not what you're going to file.
Well, the last year I filed was a few years ago. So I mean, if he does want that, that's fine.
He's still entitled to it. So give him what you've got. Now I can't make you do what you haven't done already. I can't make you give him documents that you haven't prepared already, but I can make you give him everything that you do have now.
Understood.
So can you get all that done within 7 days?
Yes, sir.
All right. If you don't do that, The only other alternative that I have is to hold you in contempt of court because you failed to do what the subpoena requires you to do. And I'd really hate to do that. So I'm going to give you 7 days. And if Mr. Pagels doesn't think that you fully complied, he knows how to get the court's attention, and we'll be back in court for that. You understand?
Yes, sir.
All right. Any questions that you have?
Just one, if he could provide an updated list of the information he still needs from me.
Well, he gave you a subpoena. Looks like back on January the 12th. I signed, well, no, it wasn't then. It was, I signed it on December the 9th, which has a list in it of all of the documents. You have that?
I don't believe I do.
Mr. Pagels, can you send him that list?
He's received the subpoena 3 or 4 times, Your Honor. That's just part of what's going on here, but
But I apologize.
Whether he's received it or not, you want your stuff, Mr. Pagels?
yeah, no, I'll be happy to try to send it to him, but I don't.
I do have it. It's unnecessary. I do have it.
All right, good. So let's get that done. You've got 7 days to get all of that, meaning all of the stuff that's in that subpoena that I signed on December the 9th over to Mr. Pagels. If you don't do that, he'll contact the court. We'll have another hearing and I'll consider contempt of court. Fair enough?
Yes, sir. Yes,
right.
understood. Can I ask one more question?
Yep.
What does Mr. Pagels have on file for the amount still owed?
I don't know. You'll have to
Your
talk
Honor,
to
I'll
him
be here
about that.
I'll be at my office till 3:30. Mr. Ignatiak said he was going to stop by. I'm going to be leaving at 3:30.
All right, you guys can talk either offline or by phone or by stopping in. Once you drop off the documents, he'll give you an update as to how much you still owe. All right, that's all for today. Thank you both very much.
Thank you, Judge.
Thank you. Have a great day.